of both the bidders along with the members of tender committee was held on 22/11.
First meeting of bidders and
Then thereafter another meeting was held on 21/12.
okay.
And after the meeting of 21/12, a final decision was taken, my lord. That is our line of submission, my lord.
Now 21/12 last meeting.
Last meeting, and only after that the evaluation process was concluded.
Yes.
A final decision was taken.
Yes.
Prior to that, there was no final decision taken. My lord, to that effect, my lord, I'll draw your lordship's attention once again to page 58, my lord, of the state's affidavit, my lord.
Page 58. Okay.
58, my lord. This was pointed out to your lordship earlier, my lord.
Yes.
Now this says, my lord, this is from Superintendent of Tura Civil Hospital. Lordship, kindly note that, my lord. Now it says, my lord, I'll read second para. The project sanction amount with administrative approval of the NEC by their letter number so and so dated 31st March 23 is rupees 6,69 lakh rupees. Only but the tender amount quoted by the selected party and approved by the tender committee is so and so. Only with a shortfall amounting of rupees so and so. A table is given thereafter. Therefore, madam, I would like you to request you to kindly take necessary action from your end and move the government NEC for the additional requirement of fund at the earliest in the interest of the public services. Now, madam, kindly note that this is dated 20th of November.
Right.
And this is signed by Superintendent of Tura Civil Hospital.
Right.
Now, lordship, kindly comes to our affidavit, my lord.
Yes.
Of respondent number 6.
Yes.
Page 27, my lord. The same superintendent on the same very day, my lord. Same 20/11/23. The superintendent writes.
Page
27.
Yes.
Notice dated Tura the 20th of November 23. In continuation of tender opening on 8th November 23 at 3 p.m. in the conference hall of so-and-so for supply of so-and-so. Therefore, all the tender committee members, both the suppliers parties are requested to attend the meeting without fail for discussion on important issues relating to the tender. So, my lord, pursuant to this notice, a meeting was held on 22nd/11. Now, my lord,
One second. No? On the same day itself.
on the same date,
Okay.
and then your lordship has seen page 71 of the state's affidavit, the third meeting presided over by the deputy commissioner, my lord. That is at page 71 of the state's affidavit.
It's 21st December, not 22nd.
22nd November, my lord, first meeting.
Yes, where's that? Page 71, 21st December.
Because the mention is there in the paragraph.
No, my lord, what I was trying to submit, my lord.
The hospital management also put forth a meeting conducted on 22/11. Where's that meeting 22/11 minutes?
That has not been
My
annexed.
lord, minutes have not been annexed, but
Then?
it records, my lord.
No, then we can't go by the records. What is it? What is
No,
the
my lord,
22/11?
I'm trying to point out the notice, my lord. The notice
No,
was,
why did the Advocate General not refer to it then?
that has not
22/11?
been annexed, my lord.
Yes, why?
That I'll not be able to answer, my lord, why, because that is not in our
Then the
position. my
records
lord.
be necessary.
Records, everything is there, Malaj. Only this minutes.
22/11 is not here.
Only this
It's
minutes.
not there.
Only this minutes.
But this establishes, my lord, that there was a meeting on 22/11 because there is a notice, proper notice for that, and there is a reference to that, my lord, in para.
No, no.
In
See
para
this
3.
one. Just see this, the one you're referring to, the para 3.
My lord.
It says hospital management
Also put forth comparative statement against the required as was directed by the chairman in the previous meeting
as was directed by the chairman.
on
It's not a
22/11.
question meeting. It's put forth comparative statement. It's just that a comparative statement was prepared.
In the previous meeting, my lord, in the previous meeting conducted on 22/11/23, there was a meeting on 22/11.
So this chart shown by Advocate General means this is 22nd meeting pursuant to that.
Yes, my lord.
This specification.
That's what I was
requirements.
pointing out, my lords. This is a chart prepared pursuant to that meeting of 2211.
2211.
Okay.
Contrary to what was being submitted by the state.
But that was considered, the chart was considered in the meeting, in the third meeting. my lord.
You mean to say, then who did assessment then, so comparative chart? Who prepared it?
Well, the chart was prepared and chart was
And who did the appraisal?
in the third meeting, my lord. The chart was considered because it forms part of the minutes of the third meeting, my lord. This is annexed along with the resolution of the third meeting.
Okay.
So, my lord, what I am trying to submit, my lord, that till 21/12/23, when the final decision was taken to award the contract to, we were found most suitable. There was no final decision taken, my lord. Though there may be some, may not be a very correct English to write in those resolution, my lord, but nothing had crystallized in those meetings, my lord. 8/11 or 22/11 also. But to that effect, I'll only place one decision, my lord, if your lordship kindly permits me.
Starts at 171. Starts at 171.
Lordship, kindly come to flag F, my lord. Delhi Development Authority versus Hello Home Education Society. Para 19.7, my lord, at page 161.
Para?
19.7. At page 161, my lord.
Yes.
Para 19.7.
Yes.
The issue relating to internal notings as to whether it would confer any right or not has been adequately dealt with and settled by series of judgments of this court. It is well settled that until and unless the decision taken on file is converted into a final order to be communicated and duly served on the party concerned, no right accrues to the said party. Mere notings and in principle approvals do not confer a vested right. Relevant extract from judgment of this court in this regard are being reproduced hereunder. Bachittar Singh, the question therefore is whether he did in fact make such an order. Merely writing something on the file does not amount to an order. Before something amounts to an order of the state government, two things are necessary. The order has to be expressed in the name of the governor as required by clause 1 of article 166, and then it has to be communicated. As already indicated, no formal order modifying the decision of the revenue secretary was ever made until such an order is drawn up by the state government cannot, in our opinion, be regarded as bound by what served in the file. Lord, may I refer to page, next page, my lord, para 22.
Yes.
I think it's a part of that judgment only. From the afore extracted notice of the commissioner and the order of the vice chairman, it is manifest that although there were several notings which recommended consideration of the appellant's case for a relocation, but finally no official communication was addressed to or received by the appellants accepting their claim. After the recommendation of the technical committee, the entire matter was kept pending. In the meanwhile, a new policy was formulated and the matter was considered afresh later in the year 2004. When the proposal was rejected by the vice chairman and the final decision-making authority in the hierarchy, it is thus plain that though the proposals and the recommendations of the state-level coordinator, oil industry and the technical committee, but these did not ultimately fructify into an order or decision of the DDA conferring any legal rights upon the appellants. Mere favorable recommendations at some level of the decision-making process, in our view, are of no consequence and shall not bind DDA. We are therefore in complete agreement with the appellants. So, my lord, till a final decision is taken and communicated. In this case, as I pointed out, my lord, 3 meetings were held and ultimate final decision was taken only after third meeting. So that does not create any vested right in favor of the writ petitioners here, my lord.
Yes.
why that is relevant, my lord, why I cited this decision is the document which they are relying on, the page 58, my lord, is an internal communication. The document I just read, my lord, was a recommendation to increase or avail more funding. That is a communication from Superintendent of Civil Hospital to Director of Health Services, MI.
Yes.
Now, my lord, second meeting and third meeting, my lord. I'll just try to point out few things, my lord. My lord, the second meeting is at page 68, my lord. In fact, say page 66 will be more relevant, my lord. Sorry, this is the first meeting, 8/11, my lord. 9/11 is mentioned, but it should be 8/11. my lord. First meeting and the third meeting. Well, I am referring to page 66, the first paragraph, my lord.
Maybe the hard copies of the text. Thereafter.
Yes.
My lord, the first paragraph it says, Joint Director and Superintendent, Tura Civil Hospital, IC Marak. My lordship kindly turns to page 75.
वही है तो chart.
That's the third meeting, my lord.
Yes.
At serial number 3, IC Marak is present, my lord. Then, Srimati Vinjay RG Momin, MCS, Additional Deputy Commissioner, my lord.
Yes.
At page 66. She is supposed to be the chairman of tender committee, my lord. Lordship, page 75, your lordship will find her name at serial number 2. W. Srimati Vinji Momin, MCS, additional my lord. Then your lordship will see at page 68, my lord. Page 68, lordship will see 3 experts are mentioned, my lord. It was pointed out by my friend. The radiologist, Dr. Amitabh Datta, is a 5th paragraph, my lord.
Yes. Yes.
3 names were there. Amitabh Datta,
Sangma,
Pritam D.
radiologist,
Sangma,
Dr.
and
Manma Marak.
senior radiologist, Dr. Manmay R. Marak. Now, your lordship will find at page 75.
Serial number 6.
At serial number 6
Number 6, Mummy Marak, yes.
and serial number 8, Pritam D. Sangma are there, my lord. Both the radiologists are there. And lordship will kindly note that Manmoy is the senior radiologist, my lord. So Amitabh Datta's presence or absence is of no consequence, my lord, when his senior is there, my lord, in the team, in the committee, and in both the meetings.
But can he change the opinion just like that?
My lord, even in the first was one,
one occasion he said, I don't have much experience. But then.
my lord, Manmay is not recommended, my lord. My lord, kindly come to page 68. What Manmay said, my lord. Dr. Manmay, senior radiologist at Tura Civil Hospital, stated that Megantom machine by Siemens has the reputation of being technically friendly and had more number of channels, therefore reducing artifacts, and also the software used in user-friendly. She also mentioned that, however, the poor service response for the single slice CT scan machine installed in Tura Civil Hospital by Siemens had to be noted.
It's okay. That is all. Yes. She didn't say that. It's not that she didn't support the decision of the first technical assessment on the capability.
So more or less, it appears to be neutral stand, my lord, taken.
I said, okay, fine, it's good machine, but then
But-
some
but
issues you might have because people won't
Servicing is a problem.
come, which is a common thing. Yeah, yes.
So, my lord, so the idea that was given, my lord, that is altogether new members have come and earlier decision has been overturned. Firstly, my submission is no final decision was taken. The ultimate and concluding decision was taken only after the third meeting.
But okay, so you see, it's a continuous process.
It was a
The
continuous
entire,
process.
The entire exercise, which commenced from 8th of November,
Continued on
and
22/11.
completed on 21st December 2023 is, the entire bid evaluation exercise.
In my ambas, this is a continuous
That
process.
means it's not okay, it can go up and down. today blowing hot, blowing cold. In the end,
A final decision was taken.
final decision taken in your favor.
And final decision was taken considering the factor, my lord, the price factor.
Okay.
It's almost 2 crore rupees cheaper, our machine.
This includes making of the MRI room and everything.
Yes, my lord. In fact, civil works. In fact, and not only that, my lord, one of our technician will be present there for 12 months, my lord.
Wait, so from China?
My lord, we have manufacturing facility in Houston, USA, my lord, and in China. My lord, only because something is manufactured in China may not be of relevance, because Apple phones are also manufactured in China, my lord. But whether
No, that's not a consideration.
My lord.
Not a consideration in China, fine, whatever it is. But you always have, you're a bit skeptical about, especially high-end,
No, the Apple phones,
advanced production.
because of other facilities, other economic factors, most of the US companies, European companies, they've set up facilities in China, my lord. So that doesn't mean that these are Chinese product in the sense we take it, my lord. Now, my lord, even if your lordship comes to a conclusion that these 3 meetings were not a continuous process of evaluation, my lord,
Yes.
then the question will come then the question will arise, my lord, whether the committee has the power to review its decision or not.
Yes.
But I'll place a decision of the Guwahati High Court, my lord, a very recent decision in this regard, which is ample reference to Supreme Court also, my lord. Para 30, 30, 31 and 32. 30.
This is body of decision. Yes. You've not given it in this list. Just give me the
Extra
citation.
copies there, I think just
Give me the citation.
Para 30. In the context of the present proceedings, the issue before this court is whether the Tender Evaluation Committee could have reviewed its earlier order. In the scheme of the UI, the powers for evaluation of the Tender Evaluation Committee are prescribed in the UI RFP, unlike in the case of Patel, Narsi, Thakersi, where the Supreme Court held.
No, one thing is that, see, coming back again to the terms of the NIT or EOI, whatever.
Right.
Now, whether, that allows it, we have not gone, no one has readjusted the terms of the NIT.
My lord, in my
Well,
humble,
a different thing. EOI is different, NIT is different. Yes.
but in my humble submission, this covers that, my lord.
Let's see.
If I take your lordship to the
See, it starts with that. See, he said in the scheme of the EOI, the powers for evaluation by the tender evaluation company are prescribed in the EOI RFP, like any request for, but unlike in the case of Patel, so the Supreme Court held that power review is not inherent and delegatee cannot have the power to review unless prescribed.
my lord. So, my lord,
Yes, so you want to
if I
show that
read-
from an IT,
Well,
that's prescribed.
Well, here, no, my lord. Here, what it says, my lord, in the reference to Patel Narsi Thakersi case, my lord, here the issue was what Supreme Court has said, that if it is a quasi-judicial power which is being exercised, then the power of review can only be conferred by statute. If it is a purely administrative in nature, there is no requirement that the power should be specifically conferred on any authority, my lord. Well, I'll just read few paragraphs. I'll clarify.
Yeah.
I'll continue to read from there only, my lord.
Get me your laptop now.
The facts involved in the present proceedings are different from the facts in the case of Patel Thakersi. The judgment of the Apex Court came to be considered in a subsequent decision before the Apex Court in R.R. Verma, Supra. The Apex Court therein had held that where the government was exercising quasi-judicial powers vested by statute, the power of review must be conferred by statute specifically or by necessary implication. However, the said principle is not applicable to decisions purely administrative of nature. The Apex Court held that to extend this principle to purely administrative decisions would lead to untoward and startling results. The government must be free to alter its policy or its decision in administrative matters. The relevant paragraph of the judgment is extracted below. I can skip that, my lord. Para 31 and 32, my lord. The judgment rendered in the Apex Court in R.R. Verma is as followed in a recent judgment of the Apex Court rendered in Rajesh Chandra Sood. In this judgment, the Apex Court held that the power of administrative review can be exercised for good and valid justifications. Accordingly, in view of the law laid down by the Apex Court, it is held that in administrative actions, the administrative authority is empowered to revisit or review its order for justifiable reasons. That power is inherent in the government or in instrumentality of the state, but for good and justifiable reasons. To restrict any administrative authority to review or revisit any order or policy supported by justifiable reasons where required will certainly lead to an anomalous and unworkable situation. Accordingly, the first contention of the writ petition that the Tender Evaluation Committee by its second order dated could not have reviewed the earlier order and the same is therefore arbitrary, cannot be accepted and the same is therefore rejected. So, my lord, I am taking alternative plea. My first plea is that this was a continuous process, my lord. Otherwise also, the Tender Committee has the power to review its decision, my lord. Committee action.
Yes.
My lord, my third submission, my lord, is with regard to the public project, my lord.
Yes.
My lord, I've been told that in entire Garhwals, the five districts of Garhwal, there is no MRI machine, even in a private hospital, my lord. This is the first time one MRI machine is going to be set up in a government, that also in government sector, my lord. Now here the dispute is essentially between two bidders, my lord. There is no public interest element as such, my lord.
Yes.
Whether I should do the business or he should do the business, that is the issue before your lordship. My friend has not pointed out any larger public interest why 226 should be invoked and what is such large public interest in the present proceedings, my lord.
Yes.
Now,
You don't think public interest to have a machine for healthcare?
my lord, the machine is already there. The machine is coming, my lord.
No, don't you think that you said that it's fair to two bidders is not a question of public interest?
My lord, unless there is a larger public interest involved, my lord, your lordship will not interfere in that.
Okay. Yes.
To protect his private right of doing business with the government, my lord, he has ample alternative remedy, my lord.
That's what you're getting at.
My lord. My lord, your lordship has seen, the Advocate General has pointed out that this is an NEC funded project, my lord. If, in my humble submission, if this tender process is interfered with by your lordship, my lord, it may lead to some consequences that this MRI machine may not come to that particular hospital, at least for some point of time, my lord.
Okay. Yes.
Moreover, my lord, I have been told, as far as the quality of machine is concerned, my lord, some aspersion has been cast only because we are juxtaposed against some big brand like Siemens, my lord. So even this brand is not a small brand, my lord. This is also an international brand. Our machine is functioning. This machine is functioning in Bethany Hospital, my lord, in Guwahati Medical College.
Bethany, no.
Bethany.
We've got the details of Bethany. Just look at it. Show that list. Get a print of that list. Get a print of that list.
Negrium for machines there.
Siemens. I've got the list. I've got the entire list, my lords, of Northeast.
My lord, in Nazareth Hospital, that is my instruction, my lord. In Dibrugarh Apeksha Hospital, in Agartala, another Astha Hospital, in Guwahati Tulip Hospital, and our CT machines are functioning in Kokrajhar Medical College, in Guwahati Medical College, Jorhat Medical College.
Okay. Anything else?
And lordship will kindly appreciate what has been pointed out, my lord. I may once again read that particular provision, my lord. It says, my lord, that the hospital society will not be bound to accept the L1 lowest bidder. My lord, in my humble submission, the interpretation of that would be, if there are certain good reasons for that, will not accept L1. But tender jurisprudence of this country still insists that L1 should be accepted unless there are justifiable reasons for that.
Yes.
My lord, had it been the case that L2 has been given, my lord, and L1 has been excluded, maybe my friend would have a better case than my lord. Here we are L1, my lord. So once it is L1, my lord, no further justification is required.
Your tender says otherwise. Then
My lord, tender, that's what I'm trying to submit. It says it will not be bound to accept L1. So I point out the wordings, my lord, the exact wordings.
it's all right.
It says will not be bound to accept L1.
You got that list?
So some exception is created. So, and that is only an exception.
So you mean to say, by these wordings, the tender, it gives the owner of the work or owner,
Right.
the protagonist, whatever, fair play in the joints, that he has to have that latitude and the freedom.
To accept L1 or
the
for
freedom, the freedom to serve as best institution,
my lord.
like notwithstanding any other preconditions that may exist.
In my humble submission, yes, my lord.
That means that
Because the wording
that interference should be limited. That
should be very limited. My
should be
lord.
very limited. Yes, of course.
My lord has seen maybe the certain resolutions are not very well worded, my lord.
Not very happy.
Very happily worded. But Lordship is aware how things happen
Not aware of
sometimes,
anything. Not only by materials on record.
my lord. But Lordship, at least will see that the continuous process, my lord.
No, that yes, but then the thing is that whether there should be continuous process at all,
My lord.
because if that's the only thing, whether it should be at all, whether this having continuous process doesn't seem to be deviation from
My lord,
tender
then in
process.
my humble submission, estoppel will come in picture, my lord. He went and participated in both the meetings, my lord.
That is a valid point, of course. That could
That waiver, acquiescence, and estoppel will come, my lord. He can after participating, my lord.
Only thing is, anyway, we'll record that in the judgment. Anything else?
So, my lord, in my humble submission, you also will see my friend's prayer is only to set aside, my lord.
No, it's to recall the award.
Set
To,
aside
re- to recall the work order. There is no further prayer my lord, to award the contract. And in my humble submission, Lordship will not do that, even otherwise, my lord. So,
We can't direct-
so the question remains now, my lord, whether this tender process should be set aside or they should be left to avail alternate remedy as available to them in law, my lord. But looking at the larger public interest, for 5 districts of Garhwals, I think 5 districts, my lord, the first MRI machine is going to come, my lord. So kindly appreciate that aspect of the matter, my lord.
No, that is court is alive to that aspect. That is why court is very concerned to hear it now, because if it's such important installation that will serve the needy people,
My lord.
then I mean that is one thing which that you should, when you acquire such an asset, it should be done in probity and transparency
That is why, my lord,
in matters of public revenue and public.
that is why the public revenue has been taken into aspect, my lord, into consideration. The price difference is staggering, my lord. And plus the
So your case is that the cheapest and best.
cheap and best, my lord. It is possible, my lord. Cheap can be best, my lord.
Yes.
Until and unless there's a,
If tourists who come to Shillong, no, want the cheapest, want the best.
if government has some fashion, if someone has fascination for a brand value, my lord, the cheap can be best, my lord.
Of course, yes. That's it.
And my lord, they participated in 2 of the meetings, my lord. His lordships in November and December.
Those 2 letters, notice.
They filed the writ petition in the month of May, my lord, allowing the third party rights to be created. And we have done a substantial portion of work, my lord. Civil work is almost
Meaning? You already have-
Order for machinery has been placed, my lord. A lot of advance.
But then the work order has been stayed. How do you do the
My
work?
lord, before that, my lord.
When did you commence? When is the work order dated?
9th March, my lord.
9th March. 9th March 24, and And the interim order of this court?
This was just last week, my lord. 7.5. More
When
than
did he come to court?
7.5 minutes.
He came 7.5, unlisted.
It's unlisted.
Because at that point of time, Balaj, we were not aware that there was any work order. On 7.5, it was disclosed by the Advocate General that there is a work order.
Was it in this left page?
But then, subsequently, when they filed the writ petition, Balaj, that's when they came up with that.
How long does it take to install an MRI machine?
My lord, approximately we were thinking of completing it within 3 months, my lord.
90 days.
90 days.
It takes 3 months to install an MRI machine.
To bring, my lord, the transportation is quite an issue, my lord.
You know what they transport? That's an issue. Yes.
That list has come.
What's in Section 3? Some shelves have been broken.
The civil work, my lord, that doesn't take. More importantly, the order for machine has been already placed. My lord. Substantial amount of advance has been paid.
See, the one disturbing thing is that why did this whole thing kickstart after the letter of that after your letter at 18. That's the only thing. See,
Our letter is dated
1811 letter. How do you explain it? 23. Because that was before. That was before any. See, before, because why? Just to clarify, to clear the air. The thing is that now you say your meetings one. The first meeting was 8/11 was the bids opened,
bid
right?
opening, my lord.
Then 22nd 11/23 was the first meeting the bidders all were called for, right?
My lord.
And 21/12/23 settled. Now the letter, your letter is 18th. And after 18th, then that meeting, second meeting took place, calling, like you see, calling the tenderers and the bidders and the.
My lord, we presented our case that we are L1.
What caused you to write that letter then?
My lord, what prompted us, my lord, we were L1, my lord. And every L1 will have a legitimate expectation to get the contract, my lord.
Notwithstanding the fact that L1 is not to, is not necessarily be settled the contract as per the
My
terms of
lord,
the tender.
once again, L1 has a legitimate expectation, my lord.
Of course.
Under the Indian tender jurisprudence, my lord.
Of course.
Exceptions are created, my lord. Exceptions will be applicable only in certain circumstances. So that is why I presented my grievance that I am L1, why I am being excluded.
Let's see the letter again. Where's that? Which page is that?
Page 53.
Of the petition?
No, my lords, of the
Page 57.
57, my lords, sorry.
Of the affidavit?
Exactly.
State as
One's, respond number one's up.
That we are L1, my lord. And for an exam, a topper has a legitimate expectation, my lord, that he will be appointed, my lord. And a second topper is appointed, the topper will have a right to at least write a letter, my
No,
lord.
no, sir, no, just that. Just that. What prompted you to write the letter?
I wrote only that I am L1.
Because the financial bids opened the same day on the 8th.
On it.
On 8th, we wrote on 18th, my lord.
With reference to so, the power that was open, was check qualified for. Yes. So your arguments are that nothing was concluded after opening of bids and exam financial bids, and even after taking an assessment.
My lord.
Nothing was concluded.
Nothing was concluded. 2 more meetings happened and they participated in the meetings, my lord.
That will go against them. They've suppressed that part. I mean, they've not annexed that in anything. Yes. Reply?
First is that list, not to deal with everything. The list of machines, my lords, which have been given by us. Lordships will see at serial number 11 is Guwahati Medical College. Serial number 12 is Guwahati Medical College. So one is a 1.5 T machine, my lords, which is under supply. One is a 3 T machine. Serial number 27, I've just marked the major players, my lords, not the private hospitals. At serial number 27, your lordships will see RK Mission Hospital, Itanagar. At serial number 36 is Negrims. At serial number 38 is DHS, my lords, Government of Meghalaya, DHS, New Order. At serial number 42 is Borpeta Medical College. 43 is Agartala Medical College. 44 is Tripura Medical College. 45 is State Referral Hospital, my lords, of Mizoram. And 47 till 53 is all Tata Cancer Institute. So everybody is, my lords, buying the Siemens machine. That's beside the point, my lords. And this, my lords, your lordships would find mentioned in the minutes of the tender committee, where they say 53 machines are already supplied by them. Now, the first aspect, my lords, that I would have to deal with, which my learned friend has, my lords, urged, is that it was a continuing process.
Right.
Which is why I again come back to the two aspects. And something, my lords, which both the state and the private respondent didn't deal with, is the letter of the Government of Meghalaya, my lords, giving the mandate into as far as how the tender is to be opened. I'll take your lordships to that, my lords. My lords, this is page 55 of the counter affidavit of the state. Now, before we read this letter, my lords, we'll have to bear in mind that the management of Tura Civil Hospital is already in place. What the government says is, my lords, with reference to so-and-so, 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 may constitute a purchase committee through the executive committee of Tura Civil Hospital. So, under Tura Civil Hospital, my lords, a purchase committee is to be made. So, it's a specialized committee.
Yes. Yes, purchase committee.
With at least one technical expert. Now, this at least one technical expert would mean, my lord, somebody who is not part of the Tura Management Committee, Tura Civil Hospital Management Committee. And which is why, my lords, the 2 pages become very relevant. I'll take your lordships to the affidavit of affidavit is here. Affidavit of the state, which my friend again referred, my lords. The composition of both those 2 committees become very relevant. Your lordships would recollect why Dr. Amitav Datta is very important. Because he is not from Tura. He is coming from William Nagar, my lords. He is outside the jurisdiction of response number 5.
All from Tura.
And they are part of that hospital management committee. So, when we are talking fair and transparent, my lords, some independent member is there who has nothing to do, over whom R5 will not prevail, because everybody else in this committee, R5 will prevail. He is the deputy commissioner, he is the chairman.
Yes. Where is it written here?
My lords?
That outside.
Well, it's here. In the minutes of the meeting, if your lordships may kindly come to page 68.
One second. No. Where it says that, that...
No, at page 55 it is not says. It says what, I'll read page 55 again, my lords. The purport of this has to be understood, my lords. I'll read it again. With reference to the subject cited above, I am directed to invite your reference to your letter number so-and-so, may constitute a purchase committee through the executive committee of Tura so-and-so for procurement of MRI machine for the hospital in alignment with its designated functions overseeing the procurement of materials, equipment, etc. It is mandatory for the committee to include at least one member with technical expertise in the relevant field. Now, Tura Civil Hospital already has these 3 people. So, my lords, fairness would demand that if I am buying something, my lords, and it is an in-house decision, it may not always be correct. So, for being fair, somebody from outside, from some other district over whom R5 will not have any, my lords, influence, is brought in. Now, very interestingly, my lords, what my learned friend is arguing, where it falls flat, is that if it is a continuation of this entire process,
Yes.
then where is Mr. Amitav Datta? He's an integral part of the tender committee. As a matter of fact, he's important if he's independent. Everybody else is from Tura. He's one person who's from William Nagar. You invite him. If it was a continuation, my lords, why suddenly decide no, this gentleman is not required? If it is a continuation, my lords, the same quorum has to be there. So
Okay, yes,
it
then-
is not. It cannot be a continuation.
Okay.
That's number one, my lords. That's my first submission.
Yes.
The second submission, my lords, and with all due respect to the judgment of the Honorable Guwahati High Court, whether it is review is permissible, that's the second thing I would have to deal with. First question is, my lords, in the facts of that case, it is distinguishable because there it was a review of the tender committee.
Yes.
Here it is not a review of the tender committee. Admittedly, it is the review of the hospital management committee.
Review by hospital management, not
Review by hospital, it may not be even a review, my lords, it would be an appeal appeal by the,
committee.
yeah. Or re-looking at the decision of the purchase committee, tender committee, whatever we call it. Now, that, my lords, would again have to be, we have to go back to the NIT. And I pointed out before your lordships, my lords, whether it can be called into question. Whether Deputy Commissioner would have the power to again examine, my lords, this at 15, page 25, clause 15 of the NIT.
yes.
Clause 15 of the NIT, if your lordships kindly have it, page 25. The decision of the committee on technical suitability and quality shall not be opened for discussion. So it was not for the Deputy Commissioner as chairman or any other authority to say whether it is right, whether it is wrong. So on facts, my lords, that judgment is distinguishable. And with all due respect, my lords, there is a finding by the, there's a judgment of the Honorable Himachal Pradesh High Court. Just give the compilation. Give it to them also. Give it to them. I'll take your lordships to that, my lords. It is the case of Bharat Cuisine Services Institute and another versus State of Himachal Pradesh. This is a division bench judgment, my lords. What my learned friend was referring was by a learned single judge. And your lordships will kindly come to page 155. Because this is the same issue that was bothering us, my lords, that what happens. And if your lordships kindly have page 160, my lords. It is numbered at top, my lords. There's a continuation of number. Page 160, serial number 4. Your lordships would have a look, my lords.
Yes.
The technical evaluation committee, after evaluating the technical bids on so-and-so, become functus officio.
Yes.
It's over, my lords. It's not over, open. So it cannot be, my lords, and what rightly fell from your lordships, my lords, that we cannot blow hot and cold. Today I say Siemens is good, tomorrow I say United Imaging is good. It is not open. Otherwise it will be a never-ending process. So once the technical committee, my lords, unanimously records that it has to go to Meg India because they are supplying Siemens, matter ends. Either you accept the recommendations, my lords, or what you do, you have to scrap the tender. It is not open for you to sit and review over it and say that, okay, we'll do it again. Now the confusion that has been created, my lords, and I will take your lordships, with regard to 3 meetings or 2 meetings. What happened, my lords? The tender committee recommended on 8th and 9th, my lords. Your lordships have seen it.
Yes.
Your lordships will see the dates are very relevant. On page 70, R2 at the instance of R5 writes, my lords, everybody's been called to the chambers of R5. What my learned friend pointed out from his affidavit, counter of R6, show me counter of R6. The notice that he's referring to, my lords, is dated the 20th. Now your lordships will kindly see to whom it is noted, it is sent. Your lordships have it, my lords. It's at page 27 and Exhibit 2.
Yes.
Now, my lords, please have a look. It says, therefore, tender committee members, both suppliers and parties, are requested to attend the meeting without fail. Very well. Now, Lordships may kindly see to whom it is marked. PA to Principal Secretary, PA to Commissioner Secretary, PA to Secretary, Joint Secretary, Under Secretary, Director of Health Services, Deputy Commissioner Chairman, Additional Deputy Commissioner Chairman, all the members of the tender committee. What in fact happened is, my lords, there was a phone call made to us, both the parties. I don't know what happened with them insofar as we've sought instructions. They said, you come to the DC's office. We went to the DC's office. They said, regarding your product, you give us a presentation. We were under the bona fide belief, my lords, it's a presentation. Because we are successful, it's a presentation. We'll have to inform further. And that I have clarified in my rejoinder affidavit. I'll take your lordships to my rejoinder affidavit. To R5, 1 to 5, para 23. If your lordships kindly have my rejoinder, page 20, para 23, my lords, page 11. If your lordships have it, my lords.
Yes.
Last paragraph at page 11, sub-paragraph, my lords.
Contempt 1719.
That is, in this regard, it is to be submitted that the petitioner's representative attended the meeting on 21/12/2023 only under the notion that some technical clarifications were required from them as they had emerged as the successful tenderer. Further, the minutes of the meeting dated 21/12/2023 were never communicated to the petitioner, and as such, the act of the petitioner having attended the meeting on 21/12/2023 cannot be seen as an act of condonation, waiver, or acquiescence on the part of the petitioner. And that is borne out from the minutes of that meeting itself. Your lordships will kindly see what has happened on that meeting. If I can take your lordships to the minutes of the meeting of 21/12.
Oh, the page is, it's ulta.
Oh,
It's
we'll have it corrected. My apologies.
It should be.
Well, I think it's been the problem with back to back. I guess. Well, it should have been pasted the other way.
Also, I couldn't get away reading. What should be page 11 become page 12?
It's just been. I tender my apologies. We'll have that corrected. If your lordships kindly have page 72 of the affidavit of the state. That is the minutes of the meeting of 21/12.
Yes.
My lords, what your lordships would see, the deputy commissioner 1, 2, 3, 4, 5, the fifth paragraph on page 71 is relevant, my lords. The deputy commissioner so-and-so, in consultation of the member secretary and other members of the committee of Tura Civil Hospital, your lordships, very important, your lordships will kindly note who. Deputy commissioner in consultation with member secretary, that is R2, and other members of the committee of Tura Civil Hospital.
Yes.
Who's asking for a presentation? It is not the tender committee. Yes. Has requested the officials of Arang so-and-so L1 and the officials of Meg India L2 to place their presentation for MRI machine before the committee members. Deputy Commissioner calls me and says, you give a presentation. What am I required to do? My lordships may kindly see, what did I do? Next page, page 72. The Deputy Commissioner and Chairman of Tura Civil Hospital then invited the company officials of so-and-so to present their product. The spokesperson of Mega India Suppliers started the presentation, main feature of the machine in front of all the members present in the meeting and claims the below mentioned qualities of the MRI machine. Company has its base in Germany, has business all over the world, well known for maintaining its reputation all over the world. Northeastern states, base location for the company is located in Guwahati. Machine is handy and easy system so-and-so. Machine has 3D picture quality. Machine has gradient strength. Machine is fully digitized. The machine is eco-friendly. Company assured 5 years support. Company provides 24/7 facilities. How can we say, Malaj, it's a continuation of the tender? A product, somebody asks me, Malaj, what are the highlights of your product? I'm required to tell him what are the highlights of your product. How can that act as acquiescence on waiver? Otherwise also, Malaj, if I may ask myself this question, in tender matters, can there be any acquiescence or waiver merely because you attended a subsequent meeting when you are called? Otherwise, in any government contract, what would essentially happen, Malaj, there would be 3 people. 2 people will waive the right in favor of somebody else. essentially lead to cartelization. So principles of waiver and acquiescence cannot come in tender matters. Once I've participated, I've participated. And if I may put it so, my lords, the case of the petitioner is not, my lords, that he has not been given the work. The case of the petitioner is that he was successful in the tender process. Now, somewhere, my lords, in between that letter of 20th and that meeting called by the Deputy Commissioner, something goes on. And the highlight of the tender was, the highlight of the NIT was that price is not the consideration.
Yes.
Just at the risk of repeating, my lords, I will just have to take your lordships again. Very quickly, my lords, I'll just point that out. My lords, at page 31, where the bid evaluation at 10, your lordships have already marked it. Just one line I'm reading, my lords. Lowest rate is not the criteria for evaluation. Rather, the contract will be awarded to the bidder who can provide the best quality products and services. So what my learned friend is saying there, that L1 is the rule. And yes, there are deviations. My lords, in this case, the foundation of the contract.
Could have seen that.
So when he's participating, my lords, he knows very well that L1 is not the criteria.
That is known. That is known.
And the minutes of the meeting, my lords, your lordship would have seen both the chairperson as well as the member secretary, the experts, everybody are saying, money is not the criteria. The state has come up with a plea, my lords, that it is cheaper. There is also, my lords, I am reminded of a saying in English, penny wise, pound foolish.
Anyway, though that's besides the point, because
No, and the other aspect is
L1 not being the sole criteria. That is already there.
that is settled, my lords, and your lordship starting
is there.
flowing from Ronak International and my lords, other contracts. It may not be categorically mentioned. Here it is categorically mentioned that it is for a public purpose. It is an MRI machine for 5 districts. What is being argued before your lordships? 5 districts don't have an MRI machine. We're going to have an MRI machine. Meghalaya does not have the best of records insofar as healthcare is concerned. And thereafter, my lords, the technical committee says Siemens is the best machine. No, we say we will not go with Siemens, we'll give it to somebody else because he's offering a lower rate. And, my lords, even in the lower rate, one aspect which has not been argued before your lordships is that the funds were sanctioned by NEC. The original allocations of funds was 6 crore something. They are saying, my lords, that the additional funds were there, so therefore we went for a cheaper machine. The fact of the matter remains that the tender in favor of the private respondent has also been sanctioned at a higher rate because they had to take an additional sanction of 5 crores.
Well, that's seen. That is seen. Yes.
And, well, it's what has been argued before your lordship. Just 1 second. What do you want me to show? Well, it's what I was pointing out before your lordship, what has been argued is that, my lords, I was going there, as a matter of fact, I deviated. My apologies. If we go to that second meeting of the DC, my lords, page 74. My lords, page 71, because a query also fell from your lordships, what happened on 22/11/2023 and why is it not part of the record?
Yes.
Now, the language of this particular paragraph explains what happened on 22nd. The hospital management also put forth, now who puts forth, my lords? Hospital management also put forth comparative statement against the required specifications as was directed by the chairman.
Yes.
After the purchase committee is constituted, they give their recommendations. Who was R5 to again ask, please give us a comparative statement, and now that comparative statement is being placed before your lordships? If he was not happy with the results of the, my lords, tender committee, the tender could have been scrapped. I fail to understand, my lords, what prompted R5 to say that you go and prepare a fresh statement in the absence of the expert, independent expert. And your lordships will kindly see who are the members present over here. The people.
No, that is seen. That is seen. Yes.
No, my lords, just 2 things I did not point out.
Yes.
There is a pathologist.
Psychiatrists also.
Psychiatrist, pathologist. Now they're going to decide on which is an MRI machine.
But the members of the hospital management committee. So
Which is why, my lords, the government in its right mind said, please have a purchase committee of experts. Experts would mean radiologists in the field who know, my lords, what is A from B.
Okay.
And Malaj,
One small reply.
just in para 19 of this affidavit, Malaj, I just have to take your lordships. This I had already said earlier.
But Deputy Commissioner.
Yes, Malaj.
No, that's already seen. That's already been placed.
19 Malaj, what they are saying in para 19, that so-called comparative chart that they've prepared, there is no findings. Assuming, Malaj, what they say is the gospel truth only for the sake of arguments. We just go back to this comparative chart. Malaj, it starts from page 85 till page 142. Your lordships will kindly see. Is there any finding? Your lordships will kindly see 85 to 112. Your lordships, kindly have a look at page 112. Malaj.
Yes.
Kindly have a look at page 112. There is nothing. And very interestingly, Malaj, page 113, annexure 9, is the brochure of R6. Assuming it was part of the entire record, Malaj, where is my brochure? Is the brochure of R6. So, Balaj, the other thing that I was just wanting to point out before your lordships is that just two very quick queries. Balaj. This is of course not part of the record, but since it's what my learned friend was submitting, that public purpose, MRI machines are not purchased from. It's not a question of me supplying and he supplying what was projected before lordships. The state is procuring something with public money for utilization by the public.
That goes away.
Well, it's one query that had fallen from your lordships is the product that was being supplied by us is AI integrated.
It's integrated.
Yes,
Enabled.
Court Master, please.
Is there an affidavit valid?
Yours also, AI enabled.
Page 138. No, in the state's affidavit. Is there,
R1.
is there brochure also here?
Acha.
So what was said that only our affidavit, our brochure is being
Acha.
138 is their brochure also.
Your lordships may kindly have a look at page 5, Malaj. Just above the diagram.
Yes.
Malaj, together they provide high quality automated scan procedures for variety of body regions with comprehensive guiding and predefined scan strategies. Powered by artificial intelligence, auto-align delivers automatic placement of imaging slices to ensure reproducible scan results every time. This is the product that is being given.
Okay.
Only a small rejoinder is required, my lord.
Yes. The other matters are there. They are waiting from the morning.
My lord, only one aspect, my lord. My friend has referred to a decision of Himachal Pradesh High Court, my lord. Well, here what happened, my lord, in a evaluation of any tenders, my lord, there are two stages. First is technical stage and second is financial stage, my lord. Here was a case that 6 bidders, there were 6 participants in this tender, or were technically qualified by the technical evaluation committee. Then High Court says that once you have taken a decision, all 6 technically qualified, all 6 financial bids opened, or even before financial bids are opened, the tender evaluation committee again sat. I'll just point that out in the decision itself. Well, this is altogether in the different facts and circumstances.
No, my friend is suggesting that it can be.
No, let me.
Please,
Yes.
please. I'll have to give a service.
Yes.
Give me the judgment.
Yes.
But page 160, my friend was referring to, my lord.
Yes.
But I'll read the fact. Examining the facts of the case, para 2, my lord, page 160.
Yes.
Examining the facts of the case in light of law enunciated by the Apex Court, the position that emerges is the tender in question was the second NIT issued by the respondent for supply of cooked food to the indoor patients of civil hospital, Paonta Sahib. According to the respondent, the first tender process could not be completed for want of a requisite number of technical qualified bidders. While evaluating the technical bids of the participating tenders in response to the second tender floated by the respondents on so-and-so, the duly constituted committee evaluated the bids on 6/4/23. The committee noticed some defects in the bids of 6 tenderers. The defects were name of the signatory had not been written on the photographs in some of the bids. Bank details did not carry signatures of the bidders in a couple of bids. Award letter has not been notarized in a couple of bids. The record produced by the respondents reflect that the committee took a decision to accept technical bids of 6 bidders, as according to it, these bidders had complied with the terms and conditions of submission of technical bids. The committee decided to hold that the 6 bidders had qualified the technical bids. This decision of the committee was brought to the notice of all concerned and was uploaded on so-and-so on the web portal of the respondents. The Technical Evaluation Committee, while evaluating the technical bid of 6 participants, was very much aware that the technical bid submitted by the tenders had some defects. Still, it thought it prudent to ignore the defects and took a decision to accept the technical bids of 6 participant bidder. The decision was taken for its logical and was notified to the Technical Evaluation Committee, after evaluating the technical bids on 6/4/23, become functus officio. So, my lord, here it is not a question of technical bid, my lord. Technically, both were qualified, my lord, by the bid evaluation committee. So it is not a case that we were disqualified and in a review decision we were qualified, my lord. This is a case of that nature. So this has no relevance to the present case, my lord.
Yes.
Well, it's just 30 seconds. What my learned friend just read, well, only on this issue. The next line of this para 4 is important. What he's already said. Technical committee opened, Malats, they ignored some certain things and they said, Malats, that all the bids were successful. Subsequently, Malats, in a subsequent meeting, they decided to review it. The finding at the first line of paragraph 4, subpara 4 is, Malats, this is a finding of the court. It says the technical evaluation committee, after evaluating the technical bids, becomes functus officio. There is nothing on record to indicate as to why it reopened the technical re-evaluation.
Technical re-evaluation, my lord.
Here, Malats, technical would be because
qualifying.
both for technical
be.
and financial bid. That's what I'm submitting. There were no 2 committees insofar as that was concerned. This tender is concerned. There was 1 committee only. I'll oblige.
And my lord, only one aspect. The second meeting was not held in DC chamber, my lord. It was held in Tura Civil Hospital on 22/11.
We pass orders, yes.
Well, I'll oblige.
Deeply.
27.
If you want to find bullet points, up to you. Otherwise,
Best avoided, Malats. We've burdened your lordships enough.
Deeply.
I am also not in favor of arguments and.
Only delay the matter, Malats. This is just fresh in your lordship's mind. Well, it's one thing, of course, I forgot to submit, Malats, is that we sought instructions, Malats, that even in case the petitioner comes out successful, Malats, that it takes 90 days. As my friend was saying, 90 days. Can't be done within 90 days. It takes 90 days for installation, Malats.
Yes, how much money are you going to give her?
Yes, Your Lordship. We are ready to pay for lump sum amount
How much?
at 5,000.
5,000?
5,000.
For all the years she served. For a few months she served. Give her
No, I mean
25,000.
per month.
That she served. How many months you served?
More than a year, Your Lordship.
Oh, that's good then.
But Your Lordship, that will not suffice. My
It
personal.
will not suffice because you're nowhere. It's just that because you have made out a case for your petitioner. In fact, she was nowhere. She served a few months in LP, came to UP. You're not sanctioned. You just continue teaching.
Your Lordship,
If not for the lawyer, this case would have been dismissed. But you've been very tenacious in your pursuit of this case, and whatever is coming is just because of your hard work. Let me tell you that much. That's all.
But Your Lordship, I would really like to give a proper hearing after that, then whatever.
No, that's over. You see, the funds for teacher had been still last order.
Your Lordship,
After it was heard, the priest stated does not possess the minimum required qualification, was no longer paid by the committee for services. However, this court knows that the priest entered into service at the school on a basis with effect from 8/2010. That after the school was upgraded, current service through a non-sanctioned post. The petitioner having served a number of years, therefore entitled for some consideration by the management committee. So, in that consideration, that Mr. Harindo has convinced the management committee to give 5,000 per month.
But Your Lordship, the real fact of the case is not that, Your Lordship.
There's no more real facts.
Because
There's no more real facts. The thing is that how she entered also, she's not really appointed. She just entered, she started teaching LP school, she went to UP school, and she's on an honorarium basis only.
No, Your Lordship, that's not true. My bank.
You've already argued that matter. It's already over. That part's only water under the bridge. The last part that remains, that instead of just dismissing your case and saying you have no vested right, that we said, okay, fine, that they consider you for a surrender. You tell the person, you ask her.
Because I may be delayed in raising the issue of manipulation, but I got to know in 2017 when they stopped my salary, Your Lordship.
Sorry, we have to go and materials on record.
And what about the period of amount I've taught in the school, Your Lordship?
That they'll
14
consider,
14
We have
they'll
to
consider how many months you've taught. For that amount, they'll
And
pay
Your
5,000 per
Lordship,
month.
now where I'll go, I'm above 40 years of age.
We cannot do anything. Very sorry. Some hard luck cases. You won't have got anything. It's just that because you had argued the matter, you said that yes, she had rendered service, though the way she was appointed, the way she was retained, how she was, there's no records. You ask your client, they're willing to up 45,000 for the period you've worked. She's still working.
She's still working, Your Lordship. And as I said, Your
Come to school.
Lordship,
She came to school, but now we have very less students.
What does she do?
So-
You're allowed to teach till now also?
No, we don't allow her
she's
to.
teaching, Your Lordship.
No,
Your
no,
Lordship, if I may be allowed to place my argument, Your Lordship. On the last date, I have requested Your Lordship to hear my argument. After that, as Your Lordship, please.
What do you want to say?
What else
Yes,
we
Your
will
Lordship,
have
as-
accused now?
The only thing is
Everything
for a fixation of that. Consideration by the managing committee.
Because the letter that I have written for them to refer me as a sanctioned teacher.
You're not qualified. That is why the whole problem started. You don't have the minimum required qualification to be a sanctioned teacher. That is the last hearing, you remember, I have to quote, not waste
No,
his
Your
time.
Lordship, but I have a degree, I have a B.Ed. And even the other teacher who is in posted, kept in my name, she, at that point of time, even she is 10 plus 2, Your Lordship. And the fact of this case, Your Lordship, Alban, Shabong, and the petitioner, they were the first sanctioned teacher.
What has been done, other schools adjusted from the sanctioned teachers post, they paid you. So now, see, that is the thing.
Now we don't have funds. We don't take
Your Lordship,
fees from the
but-
student.
Take a call on it to take down. Mr. Keith Khandor today has submitted that pursuant to the order dated so and so, dated 1/5/2024, instructions have been received, and that the managing committee of the school is ready to pay the petitioner ₹5,000 for every month that she has served. Stop MS Miosai. Next para, however, seeks to further out the case. Notwithstanding this, he is directed to communicate to her client the offer made by the managing committee. Otherwise, nothing will be coming. You're not qualified, you're not qualified. Yes, next matter? I thought some other matter was there? No.
They will
You're taking instructions. Yes.
All right.